The secret: win your case with subpoenas. You're in court, you're looking around, and you don't see any witnesses. How are you going to win a trial? The social worker has all the evidence, and it's just you and your attorney. What are you going to do? Hi, my name is Attorney Vince Davis. I'm a lawyer here in California, and I'm an expert at representing people in juvenile dependency cases. Whenever you have a trial or contested hearing, as they use the phrase in CPS and DCFS cases, it's going to be difficult for you to win a case when you don't have witnesses there to testify on your behalf. What type of witnesses? Well, you can be your own witness. But generally that's not going to be enough because the social worker has probably filed a report that's about this thick. That report has all types of evidence in it, from hearsay to clearance. And so all of that evidence versus you on the witness stand, in my opinion, gives the social worker an advantage. And if the judge rules in the social worker's favor, it's probably because you didn't have enough witnesses or exhibits at the trial in order to win. So what is a subpoena? A subpoena is a document that requires a witness to show up to court and to testify. And in some instances, a subpoena is also a document that requires a witness or a custodian of records to bring documents and exhibits to trial so they can be introduced into evidence. Let me give you an example. Recently, I told a client that the therapist had to write a report and give it to me, and I wanted to introduce it into evidence. I also told the client that the therapist had to be there to testify that that was a report that she had written. Both the client and the therapist thought that was a waste of time and money. I agree, but unless you are the social worker, you cannot introduce hearsay and documents into court without the person who prepared that document to be present in court. Now, in some instances, the document can come into evidence if the other attorneys agree that it can come in without the therapist being there. But that's rarely the case. Most of the times, you're going to bring a therapist to court. He or she is going to testify positively for you. And do you think the county or the social worker's attorney is going to agree that that therapist's report can come into evidence? Additionally, when you have a live witness on stand, in my opinion, it's more persuasive than the bare report. So always have your therapist there to testify for you. Now, I'm going to show you a form that's used in California. This form is called an order to attend or provide documents. It's a mandatory use form. In other words, other types of subpoenas should not be used. This is the form that should be used. And it's also known as a JV 525 form. So if you can Google that information or Google that number, JV 525, you can get a copy of the form. You should definitely fill these out with your attorney's guidance, or ask your attorney to fill them out. Because if you fill them out improperly, they become invalid. After they're filled out and completed, the subpoena must be served personally on the witness. Leaving it at the front desk or the reception desk of a witness's office, putting it in the mailbox of the witness is no good. You have to actually serve it. The best way is to Google and find a local process server who is registered in your county and ask him or her to serve the document. Another good way to do it is have the sheriff of your county serve your subpoena if you have enough time. There is generally a cost associated with having the registered process server or the sheriff subpoena witnesses, but it's well worth it if that's a vital witness. The moral of the story is subpoena your witnesses and subpoena your documents to court. When the county council, who represents the social worker, sees that you have witnesses lined up, ready to testify, they become more reasonable. It's when you don't have any witnesses and you try to win a trial by your attorney just arguing. Your attorney just arguing equals no evidence. By law in California, an attorney's argument is not evidence. You must have the evidence to win and to beat the social worker in court. You know, you're probably listening to this because you have a CPS or DCFS case here in California. I answer questions like yours every day, and I'd be happy to answer your questions. Please call me at 888-888-6582, and I'll give you a free consultation. That's 888-888-6582. Do me a favor so that we can keep these videos going. Subscribe to my channel and give this video a like. And also see my other videos on YouTube.